For hearing and order 41/11, Action 24, 2nd Bill 668 of 2016.
Appellant absent. By way of last word, I'll dispose this case on 12th March.
Item 25, 2nd Bill 579 of 2017.
My senior counsel is arguing this matter, and he's out of station, and he had to go for a medical checkup on urgent basis.
Counsel for the appellant sees the gentleman on account of medical reasons of the agreeing counsel has taken some. क्या कहता है बेटी?
Morning he called up that he is not feeling well and that due to that he had to go out of station for medical checkup.
Item 26, 2nd Bill 98
Basically, yesterday we were not able to
of 2022.
Your case? Whose case? Your case?
26.
SC 98 or 22?
Well, it's 19.
Name of some other counsel. ठीक है ऊपर नहीं लिखा हाँ आपका नोट्स आगे yes you can base it from there.
So we are appellant. Originally, title suit number 20 of 1996 was filed with a prayer for a declaration of right, title, interest, and position, and for the entry made in the record of right during the survey to be declared as illegal and not binding upon us because the entry has been wrongly made. In this case, whatever this property in question is, this would be very relevant for us. Khata number 178, plot number 344, 3 decimals, and plot number 3345, 25 decimals. This is the total area of the village Jumri Tilaiya district Hazaribagh. Plaintiff purchased this property from one Chotu Ram Badani by virtue of the registered sale deed on 12/2/1962. Consequently, upon the plaintiff was in regular position of what
Chotu Ram had purchased the property in 1957 as per you know.
No. The Chotu Ram he has purchased the property in the year 1937 from the recorded tenant. And from Chotu Ram, we purchased the property in the year 1960.
Oh, there is one deed of 1937. This is dependent exhibit number.
Defendant exhibit number.
And you are the plaintiff.
We are the plaintiff. Because this is admitted fact so far as defendant are concerned, because the defendant number 3 and we belong to same genealogical table. So this is we did not exhibit it, so therefore they exhibited it. So now after the purchase of this property in the year 1962 from Chotu Ram Badani, and Chotu Ram Badani is none else than he is my father-in-law, Chotu Ram Badani. Consequently, from 1962, we were into the continuous position. Thereafter, in the year 1967, thereafter in the year 1967, there was a revisional survey was conducted in the Jumri Talaiya. Consequently, the old plot number got a new plot number, and these two plots 3344 was converted into 7188, and the old plot number 3345 was converted into that was again bifurcated into two plots. That is not the subject matter of suit. However, since these two plots was recorded in the name of Ram Gopal Nath, father of defendant number 1, and plot number 344 was recorded in the name of Chotu Ram, defendant number 2. The dispute arose herefrom. Because this is a self-acquired property, I have purchased from my father-in-law, but at the time of revisional settlement, these two property got recorded in the name of two different persons. One person is Chotu Ram. He is not the Chotu Ram of my father-in-law. Who is my father-in-law? He is not the Chotu Ram. He is the son of Bodhu Ram. यहाँ पर कंफ्यूजन हो सकता है बिकॉज मेरा फादर इन लॉ भी छोटू राम है और ये भी छोटू राम है. Defendant number 2. So now here the dispute arose. Since this is my purchased property. So and how can this wrong entry be made in the survey record of right? Exhibit 3 is this is that is my sale deed by which I have purchased. So initially it was said that okay, there will be a deed of settlement and there will be a correction so far as the entries are in concern. Then consequently, they denied having making necessary correction in the record of rights. Resultantly, having no way out, we filed a title suit. Title suit 20 of 1996. When we filed a title suit of 20 of 1996, then the suit was filed against three persons. One, Kesharmal Daruka, who is the son of Ram Gopal Nath, छोटू राम सन ऑफ बोधू राम, इन दोनों के नाम से रिकॉर्ड हुआ था रिविजनल सर्वे में. एंड रामचंद्र राम बदानी सन ऑफ छोटू राम. हम बहू हैं छोटू राम के और ये बेटे हैं सन ऑफ छोटू राम. बिकॉज इन कॉन्नाइवेंस विद दैट they didn't allow the correction of revenue settlement record in my name. So therefore, a title suit was filed with two prayers: declaration of right, title, interest and possession, having supported by my sale deed of 1962, and consequently, challenge the entry made in the record of right. After filing of this proceeding, defendant number 1 and 2 did not appear. So the matter went up ex parte against them. Defendant number 3, he appeared and he filed the written statement. The contention which has been raised by the defendant number 3, is that in the year 1954, the case of the defendant number 3, serial number 7 in my notes, has averted in his written statement that Chotu Ram Badani took a loan of 2,71,838 from the LIC before 1954, pledging. Here is very relevant part nullers. CS plot number 3345, 3347 and 3348. There are 3 plots.
Which does not match with your plots.
Yes. The first plot 3344. The 3344 plot, this is one of the plot which I bought. But one of the plot 3345 matches with that.
3345 matches.
3345 matches with that. And there are 3347 and 3348 plots which we are not concerned with.
So the property in connection with 3345 was already sold.
33 that was kept in mortgage with LIC.
That's right. There was a sale certificate issued.
Sale certificate consequently thereupon.
Yes, that's right.
And in this mallards
Sale was confirmed. LIC filed an execution case.
Yes.
Then what happened?
But this plot was not included in that.
In the sale certificate.
Yes.
Where is the sale certificate?
Sale certificate. I'm coming to that. There are
Exhibit number?
mallards. Sale certificate would be exhibit G mallards. Sale certificate that is dated 30th/6/1966. Malard will come to the schedule of the property. Page 2 of the sale certificate, Malard, schedule of the
It's
property.
not here.
Malard, so this is because this is coming for the first time, Malard,
That's right.
and
You have to frame a substantial question of law. Base a discussion in connection with sale certificate. You say that it was not included.
nowhere, Mallards, nowhere in the pleading, neither the issues were framed before the landed lower court.
You have filed it. You were the plaintiff.
Yes, I was the plaintiff. Issues were also.
Sale certificate.
Yes.
You must have said that this property is not included in the sale certificate.
Yes.
So where is the discussion?
That was a discussion made, Mallards, not in the impugn order, Mallards, but I have filed a petition for the injunction, Mallards. When I had filed a petition for amendment and injunctions, Mallards, then injunction was granted in our favor during that time. In that, Mallards, all the details pertains to, Mallards, this property not included, and in the sale certificate the plot number 334 was not included, has been mentioned. And even in the written statement filed by the defendant, Mallards, this property does not mention 3344. In the written statement, defendant number 3 very categorically said the property has been mortgaged so far as the 3345, 3347 and 48. In the written statement, Mallards.
So you have grievance only in connection with 334844.
44, Mallards, was never made, and so far, Mallards, it has been very categorically stated since the property has been sold. But, Mallards, all the transaction was with respect to the only, Mallards, paper transaction. Actual physical possession was never taken. So therefore, the defendant comes up, defendant number 3.
There was a partition suit of 1980.
1980 there was a partition suit. In this partition suit, Mallards, it has been said that me and my husband, we were also implicated as one of the parties. In that partition suit, we did not reacted or did not responded or said anything so far as the 62 deed is concerned. That is only the contention that has been made by the defendants. Though we were party, but we have never said anything, or neither we protested so far as the partition is concerned.
This property was allocated in whose name? In the partition suit.
In the partition suit, Mallards, इस पे हम क्लियर नहीं है.
वही तो है.
इस पार्ट में हम क्लियर नहीं है.
क्लियर नहीं है तो सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बने.
हम कहीं का है 10-2 मिनट विद परमिशन हम पूछ लेते हैं. what instructions I am getting, plus, though the partition suit was filed, but it was not pressed by the plaintiff alert, and during that time itself it was disposed of. There was no final order so far as the partition suit is concerned.
What is your suggested substantial question?
Let's 12. Twenty-seven.
27.
27.
Where do I get 27?
From my pleading section, that's,
Page number?
27 will be page number 15.
These are not the substantial question. Substantial question of law starts from page number 19.
Sorry, even same thing, उधर भी था. C है, page number 19. Number 2 would be D plus. D, F, G.
इतना ऐसा substantial question of law बनना है. Which one do you want to press?
That's, I would rather the C and F would be level because जो F में हम लिखे हैं argument में इसी पे place किया है whether the doctrine of least pendants may annul the conveyance of the party to the suit or it only renders substantial to the right of other parties of the litigation and therefore section 52 of the transfer of the property would not render the transaction relating to the suit property. Suit property जो मेरा जो plot है उसको I am describing as a suit property because that was never the subject matter of the litigation. Never it was rendered because consequently both the lower courts they have clubbed the both property and they have come to the conclusion that these both the properties were the property was mortgaged before the LIC and after having taken mortgage we were unable to pay, so therefore all these properties were sold. So therefore finally both the learned lower courts below they came to the conclusion since the property was custodial legis, though no issues have been framed so far as the custodial legis, but consequently the word custodial legis has been there in the judgment of the lower court as well as the appellate court and stating therein that it was in a custodial legis, it was under the because the receiver were appointed, so therefore it was custody of the court, so it was a custodial legis. And during the pendency of the suit, the pendency of the title suit before the Honorable Bombay High Court, this property could not have been alienated. Now, my contention would be, okay, yes, if I can, for the argument's sake, I can argue, so far as the one property is there. But what about my other property, that was never subject matter of challenge. My sale deed was never upon the challenge. My sale was never challenged, my lord. My sale deed was never upon the challenge. My sale deed has been no declaration. My sale deed has not been annulled. No challenge, no praise has been made, my lords.
But the property was auction sold.
When the property was auctioned.
But the property was auction sold.
प्रॉपर्टी
Two of them.
हाँ प्रॉपर्टी ऑक्शन सेल हुआ और ये जो डिफेंडेंट नंबर जो 3 है यही कह रहे हैं कि जो 5 लाख रुपया जो मेरा बाकी था जो ऑक्शन सेल में मेरा बचा था बिकॉज ड्यूरिंग द ऑक्शन सेल मलर्स some of the amounts mallard has been paid by me so therefore my auction sale has been deferred but consequently mallard I was not able to pay the full amount mallard so therefore later on in the year 1965 LIC was allowed to intervene into the proceedings, Mullers, and go for the absolute sale in the year 1965. उससे पहले 1962 में the property has been transferred to me.
What is the date of or this? Why do you want that this section 52 of the transfer of property act will that? What are the dates for that?
Mullers, my dates would be relevant, Mullers. There will be 2 dates, Mullers. 2 dates would be very relevant. Number 1, Mullers, the date when I purchased the property.
When
12/2/1962, Exhibit 3. That is Mullers my
Exhibit 3.
sale deed, yes. And Mullers, the sale certificate that was issued. Sale certificate that was issued. It was issued, Mullers, in the year 1965. (23rd day of July 1965).
What is the date of auction sale?
This is certificate, Mullers.
Date of auction sale.
Auction sale, Mullers. Auction sale, there has been a repeated dates, Mullers.
What is the last date? There will be just one date
Mullers,
when the
Mullers, I'm
property
coming to
was
that.
sold.
I'm coming to that. 17/1/1963, High Court of Bombay passed an order giving liberty to set off the amount of purchase money against the amount due and fresh proclamation of sale to be held. For the purpose of valuer was also appointed for evaluation of the property. Now, thereafter, 11/5/1966, the property was fixed for auction sale.
66.
Hello.
You say sale certificate was issued in 65.
ये यहाँ पर ये जो absolute sale जो हम यहाँ पर जो दिखा रहा है जो ये जो sale certificate है exhibit G, whereas the decree for the sale dated 19 ये decree है sorry ये decree था ये और उसका whereas the order dated 23 day of July 1965 the plaintiff was given liberty to bid.
The present plaintiff was given liberty to bid.
And whereas the order dated 23rd day of July 1965, the plaintiff were given liberty to bid at the same auction sale and set off the purchase money against the amount due to them. They were also given liberty because it was put under the sale, so even we were given liberty. The date, my lords, in the schedule, in the date has been mentioned. All the piece and parcel of the land together with dwelling house thereon, situated at village Jhumri,
You are not
Tiraiya.
coming up. You are not telling me to make out a case. You just tell me how does this substantial question of law is attractive? F.
So
you
far,
don't know the basic dates.
my lords, the date and date, this day of June 1966. Sale certificate was mentioned. I bought a property in the year 1962. Finally, there were several dates of auction, and ultimately the sale was the sale certificate was given on 30th day of June 1966. So therefore, my lord, it cannot be said to have that my property was
When
under
was the decree passed?
decree in my lords.
Understood? Which ultimately led to execution.
The decree was passed, my lords. Coming here.
It was a mortgage property.
Mortgage property.
Right? So,
It was a mortgage property. My contention, my property was never mortgaged.
that is only one of the property.
One of the property.
Only one of the
One of the property.
Double four.
Double.
Rest were all mortgage.
एक ही प्लॉट है, एक ही प्लॉट and
आपका दो
other
प्लॉट है ना?
नहीं
आपका
मेरे
दो प्रॉपर्टी है.
हाँ दो प्रॉपर्टी नहीं होगी मेरा 2 प्लॉट है जिसमें एक जो 4-4 है दैट वाज नेवर द सब्जेक्ट मैटर, और जो 4-5 है दैट वाज सब्जेक्ट मैटर, उसके अलावा 2 प्लॉट और है जिससे हम कंसर्न
ठीक।
जिससे हम
तो
कंसर्न
सेल सर्टिफिकेट तो 4-5 का इशू हुआ ना?
45 का हुआ, 45 का हुआ।
हाउ डू यू क्लेम दैट?
Now, that property I am claiming, my lord, even for the argument's sake, my lords, even for the argument's sake, that property was auctioned. That property was auctioned. But consequently, that property was set off and all the entire amount was paid by the defendant number 3.
सेट ऑफ मींस
Set off उसको clear कर दिया, जो mortgage का जो
सेल
property,
होने के बाद कैसे क्लियर?
सेल होने के बाद ही हुआ, सेल होने के
परचेजर
बाद
कौन?
एग्जीक्यूशन प्रोसीडिंग वालों फाइल किए ना, एग्जीक्यूशन प्रोसीडिंग वालों फाइल किए, they were only wanting the money, they never wanted the property, so therefore
सेल होने के बाद कैसे आपका ये अनडू होगा?
यही है, this is
सेल होने के बाद कैसे अनडू होगा? And because that order by which the sale certificate was set aside, it
That-
must have been set aside.
sale, there was an execution proceeding was,
It must have been set aside.
execution proceeding में set aside,
We do not know. You say that sale certificate was issued.
set है जो ये exhibit ये है,
ठीक है,
exhibit जी
किसका फेवर में सेल?
सेल
आपके
है
favor में।
LIC के फेवर में,
LIC के फेवर.
जी
Sale certificate was issued
LIC के फेवर
with
में
the property,
जी,
right? Then what happened? Then
After
the
this-
property was released by
no, the position always remained with us, so therefore LIC filed an execution before the Hazari Park court.
So,
And in that Hazari Park, LIC said, "Ki so far as the amount 5 lakh rupees is amount due, please pay us. We will release everything and we'll go." And consequently, defendant number 3, who is the son of Choturam,
yes.
paid all the amounts.
Okay.
Paid all the amounts, and therefore the entire property was released in
Released
favor.
by which order?
There is no order as such. There is
No
nothing.
order.
There is nothing on record, my lords.
तब क्या होगा?
My
आप
humble
एक समाज
summons-
से-
There is nothing, and nowhere it has
LIC
been.
is a party in this.
LIC was also not a party in this,
So,
because इसमें LIC
so therefore, your sale certificate with respect to 4-5 attains penalty. You have only the case in connection with 4-4.
Well, I would say yes, fellas, because of the fact.
We will not frame any issue in connection with 4-5. 4-4 particularly. Second appeal number 98 of 2022. The learned counsel for Tamil Nadu is present. We submit that the suit property consisted of Khata number 178, block number 3344, area 0.03 acres, and block number 3345, area 0.25 acres total, 0.28 acres. Which originally belonged to Chattu Ram Bhadani, son of late Rupan Ram Bhadani, who had purchased by registered sale deed dated 15/9/1937, and the plaintiff had purchased the suit property by virtue of registered sale deed dated 12/2/1962. However, in the record of rights, the old plot number 3344 corresponding to new plot number 7188 was recorded in the name of another Chotu Ram, son of Guru Mandani, then I will depend number 2. And the old plot number 3345 corresponding to new plot number Roman 1 7192 and Roman 2 71, Roman 1 7191 and Roman 2 7192 was recorded in the name of Ram Gopal Nath, the bracket father of the dependent number 1. And as soon as the plaintiff came to know about the wrong entry in the record of rights, the suit was filed. Defendant number 3 was a contesting dependent.
Contesting dependent.
Dependent number 3 was a contesting dependent who stated that Chattu Ram Madani had taken loan from LIC by pledging property in CS plot number 3345, 3347 and 3348. And the property was auction sold. And was purchased by LIC. And sale certificate was also issued on 30/6/1966. The LIC had filed execution case for realization of the balance amount. And the defendant number 3, being the Karta of the family, settled the matter with LIC. And execution proceeding was dropped. The learned counsel submits that it was never the case of the defendant number 3. The defendant number 3 never made out a case that old plot number 3344 was also pledged with LIC and was subject matter of sale certificate. The learned counsel submits that the suit could not have been dismissed in connection with both old plot number 3344 and 3349. Submits that a substantial question of law be framed and decided. deed has been declared to be a sham transaction.
Well,
This deed,
this
62 deed.
62. उसी में हम कह रहे थे कि इसमें the deed was never challenged and deed can be only challenged by virtue of section 31 and otherwise it cannot be said to have been declared as a sham transaction.
The learned counsel has also submitted that the registered SAID number 1101 dated 12/2/1962 executed by Chatturam Badani has been declared to be a sham transaction. Although the said deed was never challenged at any point of time. Considering the submissions, this appeal is admitted for final hearing on the following substantial question of law. Whether the learned court were justified in holding that the SAID dated were justified in holding that the SAID dated 12/1962 was a sham and collusive document. By deciding issue number 9, by deciding issue number 8 and 9. 8 and 9 दोनों एक ही साथ.
एक ही है और डिसाइड भी एक ही साथ की है.
That's all. Issue notice to the respondents. For which recusals under speed post as well as ordinary process be filed within a period of 1 week.
Appearing for respondent number 15, 16, 17, 18, 19.
Counsel for the respondent number 15 to
20.
15 to 20 and 21. 15 to 20 has already entered appearance. No notice need be issued to the sages, to the appearance. Call for the records from the concerned court. Post on 20th of February. All subtracts the post.
Item 27, 2.21.2026.
May I please? This is plaintiff's second appeal. There were two suit lands, Schedule A and Schedule B. So far as Schedule B, it is a concurrent finding of fact, and so far as Schedule A, this is judgment of recursion. My suit was dismissed with respect to both suit property
Just a moment. Schedule A
and Schedule B.
Schedule B.
Two sets of defendants were there, defendant number 1 and defendant number 2. Now, in the suit for both suit land, Schedule A and Schedule B, my suit was dismissed. But in appeal, my appeal was allowed so far as with respect to Schedule A. But Schedule B land, the same, my appeal has been dismissed.
So you have come only against Schedule B.
Schedule B,
Is there any cross appeal?
perhaps not.
The learned counsel for the appellant has submitted that the appellant was the plaintiff in the suit. The suit property consisted of Schedule A and Schedule B, and the suit was dismissed. At the first appellate stage, the appeal was allowed only in connection with Schedule A property. And so far as Schedule B property is concerned, the appeal was dismissed. And accordingly, the plaintiff appellant is aggrieved with respect to finding of the learned first appellate court in connection with Schedule B property only.
Well, very short issue involved. Well, before going to the impugned judgment, the plaintiffs are the heirs and legal representatives of recorded tenant under SPT Act. Not giving name, my lord, only to simplify the things. Now, as per the findings of the learned first appellate court, the plaintiffs are the legal representatives of the recorded tenant and so allowed schedule relief with respect to Schedule A. Now, so far as with respect to Schedule B land, my appeal was not allowed on the ground that there was a compromise decree which was in contravention of this SPT Act. So, under section 21, there cannot be compromised by any jamabandi raiyat with non-jamabandi raiyat. This is settled. And their law point is also very much clear. I have brought the decision that a compromise decree is also an agreement. So what is not permitted to do directly, that cannot be done indirectly. So my suit has been dismissed only on the ground that there was earlier compromise decree with the daughter of the recorded tenant with the defendant number 224. So my appeal has been dismissed. Can you take, my lord, paragraph 16 of the impugned judgment? This is on page number 45. Internal page number, it is lowest. Bottom page number has been given, my lord.
Of the appellate court judgment.
Yes, appellate court. Because my appeal suit was allowed, if I could be able, because both set of defendant claimed that they were settled orally, thereafter Kurfanama was executed by recorded end. Now the Kurfanama has been disbelieved by both the courts. Now the only ground on the basis of which my suit was dismissed, it has been discussed in paragraph 16. Issues have been framed, my lord. Now, my lord, issues paragraph 16. All above issues are on the legal point interconnected to each other, so they are discussed together. On this point, the plaintiff claimed by being the heirs and successors of recorded tenant Karulal Chaudhary, who died leaving behind his son Babulal Chaudhary and a widow Manti Devi, who has a daughter Madan Devi. The plaintiff's appellants are the Nati of Manti Devi and Babulal Chaudhary, as well as the son of Madan Devi, wife of Chandrika Prasad Jaiswal, and these plaintiffs jointly filed the plain title suit number such and such, again filed a suit number such and such by the plaintiff Udinai Jaiswal, Udayan and Jaiswal, and all sons and daughters of Babu Chandrika Prasad Jaiswal, in which judgment passed on 9/4/2009 by the subject first Gota and plaintiffs being dissatisfied with the judgment and decree of above title suit number itna, but appeal signed by one appellant, Ugunal Jaiswal, and affidavit also only filed by Ugunal Jaiswal dated 5/5/9. So, appeal in real sense do not filed by other appellants, Upendra Nair Jaiswal, so and so, so. So, the judgment and decree passed by the learned subordinate court is final against those plaintiffs who do not file appeal against the past order and decree in the suit title suit 27 of 1985. Now, this appeal 7/2009 filed only by the Ugunal Jaiswal. The appeal is properly signed and supported by affidavit within time, so it is clear that after report of office, the court found in proper form and found cause of action and admitted this appeal. Respondent first party argued that they are in possession of the suit land in issue since last 15 years, which accepted by Manti Devi in title suit number 863 and title suit number 35 of 62. Both above title suit ended by compromise and accepted by Manti Devi. The plaintiff, by way of title suit number 27 of 85, paid in the court of subject for declaration of right, title, interest, and recovery of land described in Schedule A and B, which is barred by estoppel, acquiescence waiver also. The respondent claimed on the basis of Urfa and title suit number such and such and such and such. And on contest, the learned subject first Buddha dismissed the suit of the plaintiff and the appellant has no cause of action. Respondent were in possession since before the SPT Act 1949 came in existence. The SPT Act has no retrospective effect. The respondent first and second party are in possession and they erected house and surrounded land by brick wall of Schedule B land. The pleader Commissioner Tanuj Dubey found the Schedule land A and B under the surrounded by brick wall and stand house under the boundary, and by government order the road and nala passes through the land. Further submitted that Honorable High Court Jharkhand, after erecting house, land nature has been changed and not liable to be evicted from the possession of the land reported in such and such, in case of such and such. Whereas plaintiff given the cause of action in the plaint that when he went to cultivate the land, respondent objected to cultivate the land, so cause of action arose.
Each sentence is running in one page.
Yes,
किस तरह का language है?
yes.
There is no coherence.
Now,
Then
finding
we
it
can understand.
no, I can
क्या लिखे हैं?
मतलब पूरा हम पढ़ के केवल यही समझे, इसलिए हम नहीं पढ़ा, इसलिए नहीं चाहते थे, लेकिन चूंकि माइलॉट
The entire page is one sentence.
केवल एक फाइंडिंग दिखा देंगे, उसमें ये बोलते हैं कि नहीं, सो चूंकि शेड्यूल ए अलाउ कर दिए और शेड्यूल बी का नहीं अलाउ किए, पेज 53 में माइलॉट अगर माइलॉट हैव अ लुक तो पेज नंबर 53 इंटरनल पेज 53 लोएस्ट बॉटम में लिखा हुआ है माइलॉट. The appellate court found that plaintiff have right title and possession over the Schedule A land, but plaintiff have no right title and possession over the Schedule B land.
कहाँ पढ़े हैं? Page number?
Page number 53 मतलब bottom में page number has been given. पेज के नीचे में पेज नंबर लिखा
Who
हुआ
is
है.
Radhika Mishra?
राधिका मिश्रा डिफेंडेंट नंबर 224 के फादर.
They were in possession since 1936.
No. They say that we were orally settled and Kurfanama was given, but they rely on the basis of compromise decree passed in the year 1965. Kurfanama has not been produced. Kurfanama इन लोगों ने produce नहीं किया. Now
आपके के साथ compromise मतलब?
मेरे ancestor के साथ. Now that compromise decree cannot be looked into by the court because this is settled mandate of law, my lord. So, my lord, this is a very good case, my lord. Kindly allow me to, my lord, raise. Because what happens, my lord, if in the compromise.
Did you raise a plea that the compromise was fraudulent?
Yes, that there is a plea. Yes. Perhaps it has been pleaded. It has been valid. My lord, can you allow me 1 minute time, my lord? Yes. Paragraph 10 of the plan.
Is there any finding that it was wrong?
My lord, finding is here and there. Finding is here and there, my lord. I must not say these things, my lord. But there was a specific pleading, my lord. And my lord will find that I have brought the compromise petition, Exhibit 8, in order to show that how it is fraudulent. Exhibit 8, compromise decree, this has not been brought by the defendant who are heavily rely upon this. Rather, we have brought as Exhibit 8, and Exhibit 8 shows that after 1949 they are in possession. So now, my lord, law is well settled that under SPT Act, adverse possession cannot be claimed after
No,
1949.
if a person is in possession prior to
For
12
1949.
years, 12 years prior to 1949.
Then my lord
Yes.
is well aware with the full bench judgment Bharilal Jain. So finding is otherwise.
There is a finding
No, no,
that
no,
they
no,
were
no,
they
no,
had
no,
in
no.
possession
By
since-
virtue of
since 1936.
no. By the
A finding has been recorded that
this finding is on the basis of
what
no
will be the
document.
basis.
This,
There is a finding after considering all the evidences that Radhika Mishra got land in 1936 from Manti Devi and they constructed a house, boundary wall and living with the family in Schedule B property. Who after compromise of the case in 1962 filed an affidavit.
yes. So this
The
is the
case was
punchline.
based on.
Yes, this is the punchline.
This
Now, my lord, if my lord will allow me, then I will say, my lord, kindly see this finding. Now I will show. Kindly see the list of exhibit. Kurfanama, my lord has gone through. My lord has gone through the finding on the basis of Kurfanama. They are in possession of since 1937. Now kindly see, my lord, list of exhibits. Where is the Kurfanama filed by them?
No. Whatever be the basis, important is what is the date of
My lord,
possession.
any finding is
They
purpose.
are giving the if a party is in possession.
If my lord, I may be allowed, my lord, I beg apology. My lord was reading which page, my lord. I can relate from there, my lord. Finding.
Page number 49.
So it is clear, my lord, from reading here. So it is clear that Radhika Mishra got land in 1936 from Manti Devi and they construct the house boundary wall living with family. Now this was the finding. Who after compromise the case in title to summons. So two factors have been taken into consideration. One, compromise decree, which was in violation of section 21. And now kindly see for a moment, my lord, list of documentary evidence filed by them. 36 का है, हम केस भी पढ़ सकते हैं, my lord. What is their case? My lord, this finding, both the finding is purpose, I am saying. This finding is on two limbs. First, they are in possession, got lands in 1936 from Manti Devi, and second, my lord, that after compromise in 1962. ये लोग तो हमको लीगल एयर पहले नहीं मानते थे रिटेन स्टेटमेंट में. They have first challenged that we are not the legal heir of the Manti Devi.
Now this Manti Devi has also been paying rent to the state government.
वो तो रैयत है ना, देगी इसीलिए तो है, इसलिए यहाँ पे डिफरेंस वो जमाबंदी रैयत है, ये लोग जमाबंदी रैयत नहीं है, ये लोग तो आउटसाइडर है एसपीटी।
Manti Devi is a Jamabandi.
रैयत की बेटी हुई विडो है।
You see, Radhika Mishra has established that Radhika Press and Bookstall was taken in the land in 1936-37 from Manti Devi for residential purpose, and from the commercial
land नहीं
report
है।
is clear that they are the legal heirs presently living after constructing the house. So the possession since 1936-37 stood established.
वो शॉप जो है ना, किडनैपर I may be allowed to place facts which they have pleaded in the written statement. ये मतलब डिस्ट्रिक्ट माइलर अगर नहीं होगा तो माइलर देखेंगे कैसे? अगर नहीं होगा तो माइलर अगर नहीं देखेंगे तो माइलर एक बार देख लीजिए कि उनका जो कोर्ट का फर्स्ट अपडेट कोर्ट का फाइंडिंग है, दो फाइंडिंग है, उनका कहना है कि नहीं 1937 से पोजीशन में है। सेकंड सेट का भी यही कहना था कि वो लोग भी सेम, दोनों का सेम, एक रिटन स्टेटमेंट फाइल हुआ है, only one single written statement. Now they placing that Urfanama was granted.
You see, whatever be the basis of the possession is immaterial. What is important is when they were dispossessed.
My lord, any finding
Because,
must be on evidence. May I say, my lord, any finding must be on evidence, or whether any finding can be given on the pleading. Now, what were the documents and what was the case? That has to be seen. So, my lord, I was not taking the my lord to the pleading. That's why, my lord, I take my lord kindly see the documents, evidence filed by the defendants.
No, what was the case of the defendant? They were in possession since 1936.
No, their case was the first that they were orally settled. Second, in 1937, Urfanama was given. Third, that there was a compromise degree. Correct, my lord? There was three pleading.
Okay.
Now, there was no evidence relating to Urfanama on the basis of which they are claiming possession since 1937.
There is a pleading of oral settlement also.
तो ओरल है और तो उसी में तो वो कह रहे हैं कि पहले ओरल ही दी और फिर 1937 में गुरफानामा दी. If my lord any document will be I am pleading that this document was given to me. Law recognizes, not recognized, I am not arguing. Rayyat is giving a kind of hukumnama to another person, I am pleading. Well, whether this document I should not brought on the record.
The point is not that. The point is that if a person, this particular provision of SPT Act 1939, if a person is in possession since prior to...
He was not in possession, that's why I am saying. He was in possession after compromise during independence.
Do you want to say that this finding of the court
is perverse?
Is based on no evidence?
Is perverse?
Perverse is one.
My lord, I am
Is
saying
it based on no evidence?
My lord, there is two things, my lord. My lord, while arguing second appeal, my lord, I am not taking my lord's time into the pleading. Just showing the important. Now my submission is, my lord, the finding is perverse because it is based on no evidence. Oral, I am not oral, not saying why, because my lord, there was a specific pleading regarding a document. And my lord is well aware regarding the provision contained in section 114. A person who is in possession is pleading that this document was settled with me by virtue of this document. And I am not bringing on the record that document, my lord.
You see, he is claiming title by virtue of that document. He is not claiming possession by virtue
My lord, he
of that
cannot
document.
claim title by virtue. He is claiming, my lord, adverse possession by virtue of that document.
Document cannot be a reason for an adverse possession.
My lord,
See, if a person has a title, he need not go for adverse possession at all. He will simply
title
claim,
SPT, my lord, my lord, can you consider? This is a case of SPT, and this is admitted case that the suit property is belonging to Jamabandi region. Now this is the concurrent finding that the plaintiffs are the legal heirs of Jamabandi JB region. Now this is the concurrent finding that these JB the defendants are not Jamabandi regions. land can only be transferred in between Jamabandi regions. Now, once there is a finding, their case cannot be that they have title. Their case is that I have, by virtue of adverse position, I was Kurpanama, I am in position, and there was a compromise degree. This was the only pleading. And if Kurpanama is not produced, then what will be the impact?
The learned counsel for the appellant has submitted that the finding of the learned court that they were किसके फेवर में ये फाइंडिंग है respondent number defendant number
Defendant number 2 to 4 के original defendant number 2.
that Radhika Mishra, right?
Yes, father.
Father of the defendant number
2 to 4.
2 to 4 was in possession with respect to the Schedule B property since 1936-37 was based on 3 facts. A. Oral settlement. B. Kurpanama, which was never exhibited. And C. Compromise decree. Passed in title suit number 8 of 1962. The learned counsel has submitted that the Kurpanama was never produced before the court, and accordingly the very basis on which they claimed possession was not produced. He has submitted that the finding of the court that the aforesaid defendants were in possession of the suit property 12 years prior to coming into force of SPT Act is not in accordance with law. कौन सा जजमेंट आपको कौन सा
ये इस पे करें वो compromise decree वाला में full bench division bench का judgment है paragraph 8 matter 75 SCC 09.
He has relied upon the judgment passed by the Honorable Patna High Court,
Paragraph 5 matter.
reported in 1975 PLGR 446 Ram Narayan Shah versus State of Bihar, para number
Paragraph 8 matter. 8. Third in this on the second page matter from fourth line. A compromise decree is after all an agreement between the parties with the seal of the court superadded thereto. It is well settled that a party cannot be permitted to do indirectly what it is prohibited from doing directly. A transfer in contravention of the provision of the Will Act will not cease to be so only because the parties have agreed in a compromise for a
और
court.
वो वाला 20 साल वाला काम कौन सा काम
वो वाला नहीं जो हौरी लाल जैन वाला है उसका
हौरीलाल जैन।
हाँ वो उसका 72 PLJ पेज 415
1972 PLJR
पेज 415
415 and has also referred to the judgment passed by Honorable Patna High Court, full bench,
yes sir.
reported in 1972 PLJR 415, Patna.
Yes sir.
Haurilal Jain.
Yes, हौरी लाल जैन versus SDO
Haurilal
sir,
Jain
Indian
versus
officer Jamtara.
SDO Jamtara. The learned counsel submits that the finding in connection with possession since 1936 is perverse. That's all?
Yeah.
Order reserved.
पर इसमें एक बार देख लिया जाता है अगर
बिना देखे नहीं करेंगे,
नहीं
बनाना होगा तो कर देंगे।
कभी मुख्य रिजर्व में फिर डिसमिस हो जाता है वैसा इसलिए हम डरते बहुत हैं इसलिए कोई डेट दे दिया जाए अगर हम गलत कुछ भी बोलेंगे तो
A person is already constructed and living on the property.
माय लॉर्ड यही
बहुत
तो
serious
ट्रेजेडी है माय लॉर्ड यही ट्रेजेडी है कि एक्टर्स ऑफ लैंड माय लॉर्ड अप्रिशिएट काइंडली दिस
हम देखिए, हम आपको कहाँ बोले कि अप्रिशिएट नहीं करेंगे,
नहीं
इसीलिए
माय लॉर्ड तो करते ही तो मैं एकदम फ्रीडम है नहीं तो माय लॉर्ड तो देखी है कि 2 मिनट के बाद डांट खा के जाते हुए तो इसलिए मैं कम से कम इसमें एक एस्पेक्ट और भी है एक अनदर एस्पेक्ट है व्हिच मे बी रिकॉर्डेड माय लॉर्ड
ऐसा नहीं है कि रिजर्व करके हम क्वेश्चन ऑफ लॉ
अरे हम भी दे आप करते हैं
लेकिन हम बहुत इत्मीनान से फ्रेम करना चाहते हैं। क्योंकि
एक-
क्वेश्चन ऑफ लॉ गलत फ्रेम होता है ना, तो फाइनल हियरिंग में हालत खराब हो जाता है
नहीं,
जज का।
इसमें
वकील साहब तो अपना बहस करते रहते हैं, फिर एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ के लिए 2-4
माय
पिटीशन
लॉर्ड
फाइल
बहुत
करते
मेहनत
रहते हैं।
करती है, वो तो हम लोग तो विटनेस है, हम लोग देख रहे हैं। नहीं, एक और पॉइंट है जो ये कहना चाह रहे हैं, ये माय लॉर्ड एग्जिबिट 8 है जो कॉम्प्रोमाइज पिटीशन, जो पोजीशन वाली बात बोल रहे हैं, इन्हीं के कॉम्प्रोमाइज में ये लिखा हुआ है उस कॉम्प्रोमाइज पिटीशन में कि दे आर नॉट पोजीशन ट्राई टू, वो लिखा हुआ है कि 15 पिछले 15, मेरे पास कॉपी है एग्जिबिट सी।
तो जब कॉम्प्रोमाइज तो वैसे ही कैन नॉट बी रिकॉग्नाइज्ड,
So cannot be
तो फिर आप उसका
आपने my lord has taken note of
that
empathy, my lord, with those persons who have constructed. My lord's finding was that.
is not my finding,
मतलब
that is
my
my
lord
concern.
हाँ कंसर्न इसीलिए हम दिखा रहे हैं कि देखिए उसमें तो कहे कि 37 से है और उन्हीं का कंप्रोमाइज वो नहीं लाए। इम्पोर्टेंट है, खाली एक बार नोट करा दिया जाए my lord, certified copy of compromise petition, they did not file Kurfanama, they did not file compromise petition. We फाइल में एग्जिबिट 8 को खाली इसमें लिखवा दो, 8 है हम लोग फाइल किए हैं जिसमें पोजीशन दिखाता है 1965 में कि पिछला 15 साल से हमें, तो हाउ इट कैन बी पॉसिबल।
The compromise petition, the compromise decree
Yes,
was exhibited by the plaintiff
as exhibit 8
as
compromise
exhibit
petition.
8.
Item 28, second appeal 218 of 2023.
इसको टाइप करके इसमें लिख दीजिए।
क्या है ये?
इसमें भी है कंकरेंट फाइंडिंग ऑफ फैक्ट है, लेकिन इसमें हमको लगता है कि थोड़ा सा एक बार पढ़ के जस्टिफाई उनको कर लेके हम पढ़े कर देंगे मैडम, कोई भी डेट दे दिए कल को छोड़ करके कोई भी डेट
At the request of the counsel for the appellant, close this case day after
लीव दे।
supplementaries.
Item 29, second appeal 131 of 2025.
Lordship, appellants are the plaintiffs. Suit your lordship. It is judgment of concurrence.
What is the error in the judgment?
Error in the judgment is that issues were framed at the time of final judgment and no opportunity of hearing was granted to the parties by the trial court. And
Issues were framed at the time of final
at the
judgment.
final judgment, in the final judgment, and no opportunity of hearing
Trial court.
by trial court.
This point must have been
Yes.
taken by the
Yes.
appellate before
Yes.
the appellate court.
Appellate court.
Where is it taken? Where have you taken this point? Before the appellate court?
Para
Para?
13 years.
Page number. Issues are framed or recasted?
Recasted.
दोनों में फर्क है?
Recasted.
Sorry.
One added, one issue was added.
What was that issue added?
Issue
Was it
number
legal
8.
issue or factual issue?
Factual.
क्या कौन सा issue add करते
So, issue number 8 was added, Your Lordship. It is on page 31.
Read
Whether,
please.
page
हाँ पढ़ी
31.
पढ़ी.
Whether the suit be decreed against the plaintiff pro forma defendant number 5 and defendant number 6 to 13E and in favor of defendant number 1 to 4, and whether the degree of cancellation dated 2/8/1994 being deed number such and such and subsequent deed number such and such are void. When the finding was given on this. Lordship, page number 13 said, on the basis of pleading the following issues has been recast. Page number 13.
Page number?
30 minutes, on the basis of pleading, the following issues have been recast. And issue number 8 has hereby
Page
added.
number 30.
Page 30.
You see, whether the suit be decreed in favor of plaintiff, pro forma defendant number 5 and defendant number 6. These are all, basically what will be the conclusion part. इसका अलग से issue बनाना नहीं बनाने का कोई relevance नहीं.
Lordship, at least
Because
you
this
know,
is-
opportunity of there are judgments, Your Lordship.
Yes,
There
yes, there are judgments. But the point is that this is the final judgment. This will be the conclusion which will be arrived at. ये issue नहीं होगा तो क्या होगा? Issue नहीं होता तो क्या होता है इसमें?
Entire finding has been given, Your Lordship. And the second point is.
What is it? And whether the deed of cancellation dated 2/8/94 are void. Deed of cancellation 2/8/94.
Lordship, case of the plaintiff is that there are 13 plaintiffs, Your Lordship, and by 5 sale deeds, they had acquired the land from Jharkhand, the recorded tenant. And they were in possession of the property subsequently in the.
Are you there for the response?
Yes. May I point out one thing, one factual thing I have to point out. Now, we are the original defendant number 1 to 4. Jahangir Khan was pro forma respondent defendant number 5. He executes a sale deed in the year 1993 in favor of defendant number 1 to 4. And for that a suit was filed by the plaintiff. Because their sale deed is after 1993. That means their sale deed admittedly is post our sale deed. So the same person, Jahangir Khan, executes for the same property. He firstly executed sale deed in my favor, and various portions of the same property he transferred in 1994 onwards in their favor. So they filed a suit for declaration and consequential relief they were filed.
With respect to 1993.
Yes. And declaration also. We filed a counter claim. This is very important. We filed a counter claim. The trial court, what it did, it dismissed their suit, allowed our counter claim, that means for declaration of their sale deeds of null and void. It allowed our claim with regard to counter claim. Only he now files one single appeal with regard to dismissal. That, Your Lordship,
Dismissal of the counter claim.
dismissal of his suit, because he was the original plaintiff. The trial court had dismissed his suit and allowed my counter claim. So there were virtually, in terms of order A, there would be, the counter claim would be treated as a separate suit altogether. So any decree passed, it was also required to be challenged. It was not done. First, this is only one of the aspects. Even otherwise on merit also, Your Lordship, I can show. But here, as Your Lordship pointed out, that was the essential issue. Because the prayer itself was, their prayer itself was.
No, if it was an essential issue, then the parties would lead evidence on this, sir.
No,
You see,
because the
now-
parties.
Now, whether the deed of cancellation dated 2/8/94, being deed number 5611 and subsequent sale deed are void.
These were
Parties will
all,
not lead
these,
issue on
the
this.
parties would not lead evidence on the basis of issues. They would be leading evidence on the basis of their pleading.
No, but the point is that if an issue is framed, the parties would lead evidence.
But this was the essential issue.
His point is that it was recasted at the fag end of the trial, and thereafter there has been no evidence. That is his
No
demands.
evidence was required.
No
But
hearing-
then,
no hearing was
Your Lordship, I am only
An issue is framed and no evidence is required by
no
whom the
required
issue is
because
framed.
the parties had already led their evidences.
If the parties have led their evidences, then why this additional issue will be framed?
Issues because the court has to give a finding on that.
If the
This
court
one
has
no.
to give a finding, the court has to take evidence.
Further evidence, Your Lordship, in terms of the pleading itself, this was the essential issue.
Maybe this was a, why did the court frame this issue at the appropriate point of time? The parties are put to notice because of through the issues. Otherwise you will say, nothing can be of this, in this manner the case cannot be decided. That after closure of the evidence, some issue is framed, how it can be possible?
Your Lordship, that was the only issue which
Then-
was the
then
parties
you
were
are-
aware.
The court frames issue with the assistance of the counsels or the assistance of the party. Isn't it? Both the parties, they give their proposed issue.
But that is not mandated in.
Not mandatory, but if the issue is framed and the essential issue has been left out, parties would certainly point out that this issue has been left out.
But Your Lordship, both the parties in this
This
particular
procedure-
case itself, the
This
parties
procedure-
had led.
Maybe that the parties had led, not led, we do not know. But reframing an issue at the fag end of, and it is not just reframing, it is introducing a new issue. This we will not permit.
There are judgments of different high courts on this.
But Your Lordship, there are other judgments also, what my learned friend is pointing out. This is not a case
We
where
will-
the.
We will simply remit the matter for the giving opportunity to lead additional evidence on this aspect, on issue number 8.
But it would then set aside the entire
It will,
proceeding
it
it
will,
had
proceeding is
taken
illegal, so
place.
it is illegal. The natural consequences will flow. If it has been illegally done, the natural consequences will flow and heaven will not follow. If you say that all the evidences are already on record, parties may not lead any further evidence. They may not lead that whatever evidence is on record, it is sufficient to decide it on that basis.
They'll obviously lead evidence, but this was the issue. Issue itself was, this was the prayer. This was a prayer of both the plaint and the written statement.
For the fault of the court, no party is going to suffer. This procedure is not acceptable. And this is at the court.
This is why.
This issue is at the court.
Yes.
You are appearing on for whom?
For respondent number 1.
And what about other respondents? Second appeal number 131 of 2025. The learned counsel for the appellant has submitted that the issues framed by the court were recasted and a new issue number 8 was added. He submits that this was done after the closure of the evidence,
At the time of passing judgment. On this date.
at the time of passing the
Passing the
judgment, and no opportunity was granted to the parties to lead evidence with respect to issue number 8. The learned counsel, on behalf of respondent number 1 to 4, has submitted that the parties knew about the core issue involved in this case, and therefore there was no need to give opportunity to lead evidence on the same.
Because the issue itself is whether the suit be decreed against.
उसके आगे भी तो है, void.
हाँ वो तो prayer था. And evidences are not led with regard to the prayer, it has to be led on the with regard to the pleading. But
However, considering the, however, it is not in dispute that the issue number 8 was framed on recast at the time of final judgment of case. After going through the improved judgments, this, I am hearing the counsel for the parties This appeal is admitted for final hearing on the following substantial question of law. Whether the learned court was justified in claiming additional issue number 8 was justified in not granting any opportunity to the parties to give evidence after failing additional issue, that is issue number 8. Issue notice to the respondent number 5 to 39,
44.
sorry, 5 to 44.
Your Lordship, authors are their own plaintiffs. They were the
They are
original
performer.
plaintiffs.
So former,
330.
but they have to appear. If he doesn't have the wakalat nama, they have to appear. 5 to 44, for which recusals under ordinary process and speed post be filed within 2 weeks from today. No notice need be issued to respondent number 1 to 4, as they have already entered appearance by Kevit. Admitted to call for reports from the concerned court. Post this case on 25th of March.
Item 30, second appeal 173 of 2025.
This supplement.
Yes, Lordship. This second appeal was preferred against the judgment and decree passed by the learned appellate court on dated 19/8/2025 and the decree passed on dated 23/8/2025. Upholding the order and judgment passed by the learned court below as a trial court, against which that appeal has preferred by the appellant, and the same appeal was also dismissed. Thereafter,
You are the defendant?
I am appellant number 1.
You are the defendant?
Yes, I am defendant, yes. I
The
was a
suit was
defendant.
decreed?
Suit for decreed against me. Thereafter appeal preferred.
What was the suit for?
Suit for declaration of the right and title of the land property at Schedule A of the plat, which was acquired by plaintiff by virtue of registered sale deed. Before coming to the point, Your Lordship, I want to come on the point of fact and enunciate it. Firstly, I want to light on the fact that my mother, Parmila Tirki, has purchased the land property in the year of 1979 by virtue of 6 sale deed, out of which that one sale deed was executed is the subject matter of challenge. That is sale deed number 11691 for area of 12 decimal.
It was challenged by the plaintiff.
Your Lordship.
It was challenged by the plaintiff.
No, actually, this sale deed was cancelled by the defendant number 1 in the year of 1981.
Cancelled
Cancelled.
unilaterally.
Yeah. Cancelled due to the reason behind it that consideration amount was not paid by the Pritam Modi
Year 19.
1980 24/181.
As per the sale deed, the consideration was paid or not paid?
As per the sale deed, as they recited in the sale deed, the consideration amount was explained of rupees 4,000 was paid. But I have objected from pillar to post that I have not received any single penny of the money. That's why reason behind your Lordship that the chirkut, that is the essential part of the chirkut, it is a training matter in the Bihar and Jharkhand also. If the sale deed was completed by virtue of money paid, the Chirkut as given by the registering authority to the vendor having need to supply to the purchaser. In fact, I have never supplied to the purchaser.
Did you produce the original sale deed in the court?
Yes.
You have produced it.
Yeah.
Where is the substantial question?
Substantial question as mentioned very initially in my page number 10 of my petition, Your Lordship. Kindly have a look to this, page number 10. Particularly, subclause 2. Whether mere execution and registration of a deed without transfer of possession and without full payment of consideration constitute a valid and complete sale in law. And again, very important.
Did you exhibit the Chirkut also? Chirkut?
In fact,
You exhibited the original sale deed.
yeah, I have exhibited the sale deed was exhibited by the honorable court.
The original sale deed.
Original sale deed.
By you.
Certified copy of sale deed. No.
Where is the original sale deed?
Where is the sale?
You say that Chirkut was not handed over to the purchaser.
Yeah.
Correct?
Correct.
That is your case?
Yeah.
Either you will produce the Chirkut or you will produce the registered sale deed.
Exactly, Your Lordship, I have not produced the Chirkut
Then
during the examination of trial. But only for I have raised the question.
that question is of no relevance.
And that was also mentioned in the several judgment, several paragraph of judgment, Your Lordship. That Chirkut was not mentioned, but the matter was raised before this honorable
That
court.
is not relevant. You have to establish your case that the property did not transfer. You retained the Chirkut, the amount was yet to be paid, and there was no complete transfer. But in absence of production of Chirkut, this
Due
is
to
not established.
Due to the lack of demand by the concerning advocate party having no aware of that fact, whether it is required or not, the thing is that Your Lordship that I have
डॉक्टर
complied.
गलत ऑपरेशन करे तो पेशेंट को भोगना पड़ता है.
Obviously, but so far as the concern of raising the point that I have not
This
handed over to the
is
Chirkut.
not a pure legal point.
Apart from other that
Expression
possession,
of fact.
apart from other that Your Lordship that possession was not also handed over.
Need not. That makes no difference.
So maybe given me liberty to adduce the evidence once again,
No.
having well known to the fact that I have been possessor of my Chirkut, and due to the
No.
advocate concern of demanding, the party concerned failed to deposit. So maybe considers in the
No.
ground, Your Lordship.
Second appeal number 173 of 2025. The learned counsel for the appellant has submitted that.
Okay.
the-
On the other point, if permitted to me, Your Lordship. The sale deed was cancelled by the revenue authority, and during the examination of chief and cross examination, that was brought on record, and the learned court below focused on that point, that sale deed cancelled before the revenue authority is not valid in eye of law.
Certainly not valid.
Certainly, but I am not raising the question as regard of this. Whether the sale deed was cancelled by the revenue authority is right or wrong. Only for I am raising the question as regard of that sale deed which was executed by mother of the defendants, whether it is valid or not. If this sale deed was not valid in accordance with law, certainly there is no question arise out for cancellation of the another sale deed. So my opinion, your Lordship, and my submission that once again this matter may be referred to the learned court below to issue frame and assent and giving opportunity to produce all the Chirkut as evidence so that proper adjudication may be made by the hands of the honorable Lordship.
Case number 173 of 2025. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 19/8/2025 2025 in bracket degree signed on 23/8/2025 was passed by learned Additional District Judge Roman 6 DT in Civil Appeal number 47 of 2012, whereby the first appellate court has affirmed the judgment of decree dated 28/4/2012 within bracket decree signed on 14/5/2012 passed by learned Sub-Judge Roman 6 EDT entitled suit number 122 of 1990. The learned counsel submits that the appellant was the contesting defendant in the suit, and though he has lost in both the courts, but still a substantial question of law arises for consideration in this case. The learned counsel submits that the
In support of my version, Your Worship, I want to refer to some judgment. Kindly have a look at this once again, Your Worship, if may permitted to handle. For the same fact that I described, merely recited in the said deed that consideration amount was paid, it is not valid unless the delivery of possession was handed over to him. And in the several paragraph number 14 and as well as another, in the deposition that was admitted that possession was not handed over. So far as the concern of this dispute was not produced before the court due to the lack of this advocate, so I am ready to, for further give the evidence Your Lordship may be considered sympathetically ground and may refer to the learned court below to once again to adduce the evidence.
the learned counsel has submitted that the sale was never complete as
Your Lordship, very sorry, I have to say that original CDP deed was exhibited by the defendant as exhibit number 1A. That is in my possession. I have a list of documents as exhibited by this learned court below. Please.
the learned counsel for the appellant has submitted that the sale was never complete, inasmuch as the possession was not given to the plaintiff the learned counsel has further submitted that a number of sale deeds were executed the learned counsel has submitted that the mother of the appellant,
Yes, mother.
Pratima
Pratima.
Tirki, had purchased properties through 6 sale deeds in the year 1979.
Yeah.
And one of them, bearing number 11961, area 12 decimal,
Yes.
was subject matter of the present suit. He has submitted that the deed was cancelled in the year 1981 on the ground of non-payment of the consideration amount
And delivering of petition.
and non-delivery of possession. He has also submitted that the original sale deed was produced by the defendant as exhibit
A1.
A by
A1.
1, which itself revealed that the sale was not complete.
Yes.
Yes, relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2011 bracket close 6 SCC 555 Janak Gunadi Devi versus Kapil Dev Rai, and also the judgment passed by Patna High Court reported in AIR 2012 Patna 189 Ram Lal Mandal versus Sri Satyanarayan Mandal. The learned counsel submits that the Chirkut was never handed over to the plaintiff, and therefore the sale itself was not complete.
Exactly.
However, during the course of argument, it is not in dispute that the Chirkut was not produced by the defendant, contesting defendant,
That is
before the learned court.
what we do.
And the sale deed itself revealed that the entire consideration amount was paid. Correct?
Yes.
I have to rise, I have some emergency. I was to rise at 4 o'clock. I have heard you, I will pass on.
Okay.
Your case could not be taken
Your
up.
Lordship, maybe adjourn for as education petition was filed and is running from day to day. So maybe
Adjourn for?
that is I was also separately.
No, it will come shortly, just
So
wait.
any order will be passed for giving liberty to the appellant to get relief from the education court, Your Lordship.
It is a technical point, specifically for Bihar. I will see what is the consequence. आप कौन है?
Item number 17 orders
आज
are
नहीं हो पाएगा.
to date.
आज नहीं हो पाएगा.
नहीं देखो पड़े.
आपका केस आप मेंशन कीजिए.
Any date.
डेट तो पड़ेगा ही. अभी तो देखिए कौन सा डेट.
Orders में है 4 दिन बाद हम लोग आसाम में.
क्या चीज के लिए ऑर्डर्स में?
Orders में अंदर respondent number 2 and 3 उसमें सिर्फ 1 और एक 60 को नोटिस नहीं गया है इसी के लिए petitioner
आज
appellant को
नहीं हो
देना.
पाएगा. नेक्स्ट डेट में आप नहीं देखेंगे. इनका मैटर करते हैं.